Good evening. I'm Melvin Raymond, attorney and counselor at law. Welcome to Raymond Law Live. Our topic on the last broadcast was sexual harassment in the workplace, which is a form of sex discrimination or gender-based discrimination. The topic for today is discrimination in employment because of pregnancy, childbirth, and related conditions. Now, discrimination because of pregnancy is another form of sex discrimination. Now, there is protection at both the state and the federal level for this kind of discrimination by an employer. As in the case of sexual harassment, here in the state of Missouri, the law which protects for pregnancy discrimination is the Missouri Human Rights Act. We did mention that in our last broadcast on sexual harassment. At the federal level, there is protection for sexual harassment by an employer by both Title VII of the Civil Rights Act of 1964 and the Pregnancy Discrimination Act. What kind of protections does the law provide for pregnancy discrimination? The Pregnancy Discrimination Act, that is the federal law, expressly and specifically provides that women affected by pregnancy and also childbirth and related medical conditions shall be treated the same for all employment-related purposes. So, again, the key is that women who are affected by pregnancy, childbirth, and related medical conditions shall be treated the same, equality of treatment. What does a case of discrimination because of pregnancy look like? First, you need to show that you belong to the class of individuals who are protected by the law. Of course, in the case of pregnancy discrimination, it is women who are directly affected by pregnancy, childbirth, and related medical conditions. So it's pretty easy for a woman to show that she is a member of the class of persons who are protected by the law here. Second, the woman, must seek accommodation from her employer. That is, accommodation for her pregnancy, childbirth, or any related medical condition. Third, she must show that the employer did not accommodate her. And fourth, she must show that the employer did accommodate others or other employees with similar disabilities or similar ability or inability to work. For example, if an employer provides accommodation for those employees who are disabled on the job, then the employer will most likely be required to offer similar accommodations to pregnant employees. Again, the idea is that you can't treat pregnant employees with respect to their condition, either childbirth, pregnancy, or related medical conditions, differently from employees with other conditions, of course, not related to pregnancy, which may render them unable to work or able to work. An employer can get into legal trouble if he has a policy of accommodating non-pregnant employees who may be impaired and while categorically failing to accommodate pregnant employees with the same restriction. There are a number of accommodations which employers offer for their employees who may be temporarily unable to work, such as sick leave, either paid or unpaid, or leave without pay. And that would allow a pregnant or a non-pregnant employee to remain on the job, for instance, in the case of a pregnant employee following childbirth. So, in general, an employer is required to treat the condition of pregnancy in the same manner as any other temporary disability. An employer cannot lawfully provide, for instance, insurance coverage for some temporary disabilities, such as, for instance, lifting or restrictions with respect to lifting, while without providing insurance coverage for pregnancy-related medical conditions. Now, there is another federal statute that is helpful in the area of pregnancy discrimination, and that law is the Family and Medical Leave Act. That's a federal law. We refer to it as the FMLA. So that is helpful also in this area of discrimination in employment because of pregnancy. What does the FMLA offer? It ensures unpaid leave or substitute paid leave for up to 12 weeks in any 12-month period for specified reasons related to the birth or adoption of a child, and also other reasons for both males and females. So the Family and Medical Leave Act applies to both males and females, including, and it covers situations including birth or adoption of a child or a placement for adoption of a foster child. Either a mother or a father can take that 12 months of leave under the FMLA. In some instances, circumstances may necessitate that FMLA leave begin after the actual birth of a child or the date of adoption. An expected mother may take leave for prenatal care, for instance, if her condition renders her unable to work. FMLA leave should be provided by an employer before the placement of a child for adoption or foster care if the absence is needed for the adoption to proceed, such as absences required for counseling sessions, court appearances, or consultation with a doctor or attorneys. We talked at the last broadcast about who's covered by the Missouri Human Rights Act. Those employers with 6 or more employees are covered by the law in the state of Missouri that prohibits pregnancy discrimination, and for the federal law is 15 or more employees. Now, which employees are covered by the FMLA, the Family and Medical Leave Act? Private employers with 50 or more employees are covered by the FMLA. Also, besides private employers with 50 more employees, government agencies, including local, state, and federal employers, and elementary, as well as secondary schools, are also covered by the FMLA, regardless of the number of employees. So the coverage is different for FMLA as compared to the Missouri Human Rights Act. And again, as I mentioned, with respect to other forms of discrimination, such as sexual harassment, employees are covered, and that is employees as opposed, for instance, to independent contractors. A employee would be a person whom the employer has the right to control their daily work activities. Independent contractors usually work under contract, or they're not as closely supervised by their employer. So that's a very important distinction, because if you're an independent contractor, then you wouldn't be covered by the FMLA or the Missouri law, the Missouri Human Rights Act. Very important. Also, as far as the Missouri law, religious corporations or associations are not covered by the state law. Religious corporations or associations are those owned and operated by religious or sectarian groups. A sectarian group, of course, is a group that's attached to a sect or a religious denomination. Those religious employers are not covered by the state law. And again, only employees are covered by the state law. We'll take your questions and comments about discrimination because of pregnancy or childbirth or related medical conditions. You can post your comments now, and we'll try to get to those as soon as we can, or sometimes during the broadcast. So feel free to post your questions or your comments. So if you feel that you have been the victim of discrimination because of pregnancy, or you know someone who has been the victim, or whom you believe has been the victim of discrimination because of pregnancy, what do you do? Well, the first step is, as with in the case of sexual discrimination or sexual harassment, you have to file a charge of discrimination. Where do you file the charge of discrimination? You have to file it with either here in Missouri, the local agency, or the state agency, and that would be the Missouri Commission on Human Rights. So you have to go there and to file a charge of discrimination because of pregnancy. They are located in downtown St. Louis, here in downtown St. Louis at the Wainwright Federal Building. Wainwright State Office Building. And you can also file a charge of discrimination with the Equal Employment Opportunity Commission. We know that as the EEOC, and they are also located in downtown St. Louis. So both the state agency, the Missouri Commission on Human Rights, as well as the EEOC, have jurisdiction over charges alleging pregnancy discrimination or discrimination for related medical conditions or childbirth. So that's the first step. Do you need a lawyer to file a charge of discrimination because of pregnancy discrimination? You don't necessarily need a lawyer to file the discrimination charge, but it is helpful to have a lawyer because then you can ensure that your charge is properly framed, and you clarify and make sure that you have all within the charge that should be included, and you have a complete statement of your charge and all of the things that should be there. This is important to make sure that you include a complete statement and a clear statement of the basis for your claim of discrimination because of pregnancy, because if you go to court later, and you can't go to court unless you first go through filing a charge of discrimination. That's referred to as going through the administrative process. You got to do that first. But if you end up going to court after the discrimination charge has been filed, in that instance, then what you have said in the charge would be the scope of what you can sue on if you end up going to court. So it's very important, that charge of discrimination, very important. So if you want to make sure that that charge is properly framed and includes in scope what needs to be included, then I would suggest that you retain competent counsel to at least discuss the charge before you file it. The Missouri Commission, or the EEOC, of course, will accept, you can go to them and they'll sit with you and prepare the charge of discrimination without an attorney. I have heard, and it's my experience, that in some instances, depending on the facts of your case, that sometimes the agencies may discourage the filing of the charge. Of course, if you don't have what looks like a culpable case of discrimination because of pregnancy, then the agency, either the Missouri Commission or the EEOC, they will tell you that if you don't have what looks to be the basis for a case, and that's proper if you don't have the basis for a case. And we discussed earlier in the broadcast what a case of discrimination because of pregnancy or related conditions or childbirth, what that looks like, what the case looks like. So that's what you do as far as the first step. And after you file the charge of discrimination with either the EEOC or the Missouri Commission, they will investigate the charge, of course, as with charge of sexual harassment, and they'll send the employer notice of the filing of the charge and a copy of the charge, and then they will go on to do their investigation. If you have the assistance of counsel when you file the discrimination charge, then they can assist with making sure that the agency conducts a proper and full and complete investigation. That is also helpful because it could lay the groundwork for the later on if you end up not resolving the case at the administrative level when you file the charge. And there is, in some instances, situations where the case can be resolved at the state level without having to go to court, but in other times and often you may end up having to sue the employer in court on the claim of discrimination because of pregnancy. So that's the steps you have to take if you want to take action for discrimination because of pregnancy. Again, if you have any questions or comments about this topic today, feel free to post your questions. Also, I do want to invite all of you, everyone, to tell us about topics that you would like us to cover in future broadcasts. We have what we call a tool called What's Your Need. You can tell us what you want us to cover on future broadcasts by simply emailing us or sending us a post on our Facebook and tell us the topic that you want us to cover. My email address is mraymond attorney, that's MRAYMOND ATTORNEY at SBC, that's S South B Bell C Cool Southwest SBC Global.net. And you can call us at the office. The number there is area code 314-534-2800. So, and also if you want us to represent you, you can also contact us. So those are some of the main points about discrimination because of pregnancy. And again, feel free to post any questions. If I don't have any questions, then we will conclude the broadcast. So again, feel free, send us questions or comments at this time, and we can deal with questions or comments at this time on this topic. Also, let me say then that we're going to go ahead and conclude our discussion on discrimination because of pregnancy. I do have, I believe, a question on our topic today. So, in our final few minutes before we close, I want to thank you all for watching this broadcast live, and also those who will watch the broadcast later. If you have any further questions or comments or want representation, then contact us you can email us at mraymondattorney at sbcglobal.net, or you can go to our Facebook, that's facebook.com/RaymondLawLive, or go to Twitter at RaymondLawLive, or you can call us at our office at area code 314-534-2800. Join us on the next broadcast of Raymond Law Live on Tuesday, February 12th at 6 p.m. Central Time. And remember, when you fight, know your rights. See you next time.